Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is going to be a video for the hometown crowd, but if you're not a Washington resident, you still might want to pay attention here because there are some immensely dangerous and offensive arguments that are being used by the state of Washington to justify the constitutional existence of our high-capacity magazine ban out here in the People's Republic of Washington. I've had an opportunity to go through the Attorney General's opening brief. It is more scary than it is offensive, and trust me, it is very, very offensive. So today, let's spend a few minutes and let's talk about Washington State's very dangerous unconstitutional arguments. Hey man, what's going on?
What's up?
Dudes that are here to detail your car are here that need the keys.
Oh.
All right, thanks, man. All right, guys, check it out. The keys to the McLaren are in here. Anyone gets into it, take it for a spin. Wait. What are you doing, man? No, that's not how this works. Okay, you guys give up?
I can't get it.
No clue. See you guys later. StopBox. Protect your family while protecting your family.
Where's my car?
Okay, so the case we're talking about is State of Washington versus Gators Guns. We are coming up for oral argument about a little more than a month from now down in Olympia. Real quick historical background. There was a challenge to Washington's magazine ban by Gators Guns down in Cowlitz County. The trial court found, shockingly, that the law was, in fact, unconstitutional and enjoined it for all of about 88 minutes. That's when a Supreme Court commissioner stepped in, stayed all of it, admitted that he'd been doing research weeks in advance before he even had the case, but I digress. The matter was stayed. That stay was upheld then by the full panel of the Supreme Court, and we are now heading into oral arguments on the merits. The Attorney General is actually the moving party here. They had to file the opening brief because they had lost at the trial court level. I'm going to share with you some of the arguments that the Attorney General's office in Washington State is making here. I'm going to give everyone a little warning right now, okay? And for those of you who've watched videos where I have to say, hey, listen, the material on here is going to be pretty infuriating, you will know that I am going to advise you to do one of three things. You can hit pause and come back when you're ready. Number one, you can go pour yourself about 3 fingers of bourbon, okay? Number two, you can start doing some breathing exercises and some mindfulness practices and things like that and get yourself a little more emotionally regulated. Or 3, just grab the barf bag and go ahead and press play when you are ready to go. What I'm going to do is share with you just a few of the arguments that the state of Washington is making in support of the constitutionality of its magazine ban. But I want to warn you that these arguments are not only deeply, deeply offensive, they are very, very dangerous because in essence, what the state of Washington is doing, and I will tell you folks in Washington, I don't know whether or not you hate your state government, but I can assure you that your state government hates you, okay? Because what the arguments that the state of Washington, Bob Ferguson's office is essentially making here is that, hey, listen, we're the state and we get to decide what people get to use for self-defense. And in fact, they truly believe that the only right that we have is a right to armed self-defense. Now, as we all know, it is the right to keep and bear arms, and if we really want to get technical about it, it's the right to keep and bear arms for any lawful purpose. Self-defense is one of a multitude of lawful purposes by which you may keep or bear a firearm. However, when the state of Washington gets themselves involved, no, they get to decide what the scope of the Second Amendment right is, and then what do they believe is most appropriate for how you should be practicing that limited scope of a right. Now, remember, the Superior Court initially ruled in favor of Gators guns, so the Attorney General's office starts off. The Superior Court's conclusion that Senate Bill 5078 violates Washington's Constitution is wrong on two levels. First, LCMs are not arms covered by Article 1, Section 24 of the Washington Constitution, which covers only weapons traditionally or commonly used by law-abiding citizens for the lawful purpose of self-defense. Okay, so the state of Washington is saying under the Washington State Constitution, these aren't even constitutionally protected at all. Here's what else they're arguing. LCMs are not themselves weapons, nor are they necessary for any weapon to function. As such, they are not arms. Moreover, LCMs are military-style accessories designed to kill more rapidly on the battlefield and virtually never used for self-defense. That is what the state of Washington is arguing, okay? That is literally the position that they're arguing with a straight face. But it's going to get a lot worse, Washington, because here's what else they argue. Second, the firearm rights guaranteed by the Washington Constitution are subject to reasonable regulation pursuant to the state's police power. LCMs are disproportionately used and disproportionately deadly in mass shootings and other horrific crimes, whereas they have little, if any, use in self-defense. Okay, so the state is now stepping in and is saying, listen, we're now the self-defense experts, so we're going to tell you what the usefulness or the utility of an item is for lawful self-defense. And then they also argue, and we'll circle back on this in a second, Senate Bill 5078 is therefore reasonably necessary to protect public safety or welfare and is substantially related to the legitimate ends of reducing gun violence in Washington. Gator's facial challenge under Washington's Constitution fails. Okay, here's the very dangerous argument that the state's making here, and I need you to be aware of this nuance, okay? They're saying essentially that, hey, listen, the Bruen case may have done away with this two-part balancing test when we're taking a look at legislation under the Second Amendment, but when we're taking a look at legislation under Article 1, Section 24 of the Washington State Constitution, oh, no. Interest balancing is totally and completely legitimate. Now, that's the arguments that they're making under Article 1, Section 24 of the Washington State Constitution. This is also being challenged under the Second Amendment of the United States Constitution. What does the state of Washington say about that? Gator's Second Amendment theory fares no better. LCMs are not covered by the Second Amendment because, again, they are not arms, nor are they necessary for any firearms to function as intended. Further, LCMs enable military-style assaults, not self-defense. So as you can see, they're using the exact same argument, they're just changing the words a little bit. But then they also continue to argue, and even if these accessories were within the scope of the Second Amendment, Washington's regulation of LCMs fits comfortably within the historical tradition of regulating dangerous and unusual weapons to promote public safety. So, Washington State is claiming that large capacity magazines are both dangerous and unusual. And then, of course, and we talk about this in the jurisdictional bubble, why you only see cases that uphold these types of bans is because they come from districts in which the states are comprised of the only types of states dumb enough to do this. And the political makeup from top to bottom in that particular circuit is the same. Of course, Washington uses this to their advantage when they argue. Following the U.S. Supreme Court's decision in Bruen, courts have all but unanimously rejected Second Amendment and Article 1, Section 24 challenges to LCM restrictions for one or more of these reasons or have been overruled. Then turning back to what Judge Basher in Cowlitz County had done, the state of Washington now is arguing. Judge Basher of the Cowlitz County Superior Court erred in concluding that Senate Bill 5078 was facially unconstitutional. Under the Superior Court's dangerous constitutional misinterpretation, civilian possession of just about any arm or accessory, from LCMs to AR-15s to machine guns and on, would be constitutionally protected. Yeah, that's exactly how the Constitution is supposed to work. And then they conclude their argument with, this is not the law. This court should reverse and make clear that common sense regulation of military-style weapons and accessories does not infringe the individual right to armed self-defense. And there it is. That is one of the most dangerous arguments, because now they are literally trying to limit what the Constitution actually protects. It's not the right to keep and bear arms, because that is exactly what the Constitution, both on the federal and the state level, protects. They are saying that the protection is only for armed self-defense, which means any of your hunting rifles, any of your bird hunting shotguns, any of your curios and relics, or things such as that, which are clearly not designed for armed self-defense, according to Washington State, they too would not be protected. Okay, that's just some of the highlights or lowlights. We will be doing additional videos as we get closer to the oral argument date. The case, once again, is State of Washington versus Gators Customs Guns. We're going to link up the state's brief down below so that you can geek out on it for yourself. 3 fingers of bourbon, breathing exercises, or barf bag before you read it. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.